Today's presenters are Joyce Francis, Nils Pedersen, and Tony Carfagnini. Nils is a retired patent attorney and a newly appointed member of the Washington State Bar. His current legal interest is estate law and end-of-life legal planning. Joyce Francis is a retired international relations professor and a longtime organizer and facilitator of adult education programs. She is also a member of the NAUA's Academy Advisory Board. Joyce and Nils, married, live in Port Townsend, Washington. Anthony, or Tony Carfagnini, began practicing law in 1979 and carried on a commercial, corporate, real estate, wills and estates, and Aboriginal law practice. Tony's professional interests and experience include business law, corporate governance, Indigenous consultation and resource development, and privacy law. For over 40 years, he acted as legal counsel to a number of First Nations and Indigenous organizations engaged in child welfare, medical services, political advocacy, renewable energy, forestry, and economic development. Tony lives in Thunder Bay, Ontario. Welcome to our three speakers. We're really delighted that you've offered your time to the Academy. You will note that we are recording this presentation, which will be approximately 1 hour, and that recording will be available soon on the NAU website, which is naunitarians.org. For those joining us live, we will then stop the recording and move to a question and answer or a comment period for roughly 30 minutes, followed by breakout rooms for perhaps another half an hour. During the presentation, I ask that you all remain muted. So with no further ado, I will turn the mic over to Joyce, Nils, and Tony and leave the program in your capable hands.
Okay, I'm in charge of spotlights, so I will spotlight us as we each speak. So hello, and I'm glad to be here with you. I have a cat that's vying for my attention here. My goal today is to offer a brief overview of the October 2022 term of the U.S. Supreme Court, or SCOTUS, as we like to call it for short. We are currently in the latter half of the October 2023 term, but we won't have most decisions until May or June. So as the October 22 is the latest term from which we can summarize, I based on their decisions. So to start, I'm going to share my screen and click these two little buttons and play from the start. Is everybody seeing that?
Yep.
Great. Let me remind you of the players. These are the 9 justices who have constituted the court since the beginning of the October 22 term. This portrait is taken every year, and there is a particular order to the arrangement. Chief Justice Roberts is always in the middle, and the others sit near him by seniority. So to his immediate right is the most senior member, Associate Justice Thomas, and then to his left, the next in order of seniority, Alito, then comes Sotomayor, Kagan, and then behind him to his right, again, the next seniority is Kavanaugh, then Gorsuch, then Barrett, then Jackson, in order of seniority. When they sit on the court, they sit in this order too, although they're all in one line. And Kavanaugh and Barrett sit to Sotomayor's right, and Gorsuch and Jackson sit to Kagan's left. So that's the players that we're going to be talking about. As you note, 6 of the justices are appointees of Republican presidents, Bush and Trump. The other 3 justices are appointees by Democrat presidents, Obama and Biden. There are a number of sort of debriefing every year of the previous term, but my favorite has always been this one done by the National Constitution Center and the Anti-Defamation League. It's hosted by scotusblog.com, which is, in my opinion, the best source of all things Supreme Court. It was founded by a lawyer and a journalist couple, and this particular series is always hosted by the journalist Amy Howe. So I want to share with you an overview that's offered by Erwin Chemerinsky. He's the dean of the UC Berkeley School of Law, and it's a summary of what he thinks happened in the October 2022 term. So let me change sharing. Oops, I need to escape from this first. Escape. And then go to a new share. I hope I do this right. This is Amy Howe, but I'm going to move to
Thank you. It's an enormous pleasure to be part of the program again. It was a momentous term in the court. I want to make a few overviews to get us started. First, I want to talk about the term by the numbers and what they mean. The Supreme Court decided 58 cases with signed opinions after briefing or argument. It's exactly the same number as a year ago. 2 years ago, the court decided 54 cases, and the year before that, it was 52 cases, which was the smallest number since 1862. It seems the court has now stabilized at deciding 50-some cases a year. That's a significant decrease from the past. For the first decade of the Roberts Court, they were averaging over 70 cases a year. In William Rehnquist last year as chief, October term 2004, the court decided 80 cases. And in the 1980s, not that long ago, the court was averaging 160 cases a year. Of the 58 cases decided this term, 47% were resolved unanimously. That's dramatically more than the 28% of the cases that were unanimous a year ago. But if you look at the last decade, the court has averaged 43% of the cases being unanimous, so it's not out of line with that. I think the degree of unanimity is probably more a function of the cases on the docket than a desire for consensus. This year, there were 11 6-3 decisions. A year ago, there were 18 6-3 decisions, and the number is 6 5-4 decisions this year. Overall, the conservative position prevailed in many of the most important cases, but there were more notable liberal victories than a year ago. I think of the last 2 days of the term, June 29th and 30th, when the Supreme Court handed down conservative decisions with regard to ending affirmative action, invalidating the Biden student loan program, and allowing individuals to violate state anti-discrimination laws on account of their beliefs. We'll also talk about decisions where the liberal position prevailed, like in finding that Alabama violated the Voting Rights Act, rejecting the independent state legislature theory, and also the court upholding the Indian Child Welfare Act. I think we saw that it is very much the John Roberts Court. Brett Kavanaugh was the justice most often in the majority. In non-unanimous cases, he's the majority 90% of the time. John Roberts was second, being in the majority 86% of the time. But Roberts wrote the majority opinion in so many of the most important cases this term. The affirmative action decision, the case with regard to Alabama and the Voting Rights Act, validating the independent state legislature theory, and also with regard to the student loan cases. The second theme that I'd identify is that I think we're in the era of the supreme judiciary. If I had to pick a single theme that unites the cases we're going to talk about today, it's how much the Supreme Court now shows deference to no one. It doesn't defer to the president and the executive branch. We'll see that when we talk about the student loan cases. It doesn't defer to Congress. We talk about the Supreme Court changing the interpretation of Title VII with regard to religious discrimination. Rather than let Congress revise the statute, the court effectively overruled a 46-year-old precedent on its own. It's not a court that defers to the states. Every case that came from state courts was a reversal by the Supreme Court. And we saw the lack of deference to state governments when the Supreme Court said that state anti-discrimination laws must yield to First Amendment beliefs. It's certainly not a court that was deferring to educational administrators. In prior cases, in upholding affirmative action, the Supreme Court stressed the need to defer to the judgment of those who run educational institutions. Chief Justice Roberts' opinion in invalidating affirmative action came to exactly the opposite conclusion, saying there should be no deference to their judgment. And it's not a court that defers to the judgment of the predecessor justices. It's not a court that gives much weight to precedent. We saw that a year ago when the Supreme Court overruled Roe versus Wade. We saw it this term when the Supreme Court overruled the affirmative action decisions. So it's not a court about judicial minimalism. It's not a court about judicial modesty. As I say, if I had to pick a theme for the term that unites the many cases we'll talk about, that we're in an era of judicial supremacy. Third and final observation, I don't think we can ignore the context in which the Supreme Court is operating right now. The Supreme Court has the lowest approval ratings of its history. A recent Quinnipiac poll had 30% of the population expressing approval for the Supreme Court's performance, 59% expressing disapproval. There were major ethics scandals revealed involving a number of the justices. It's hard to know whether this context affected the decisions this term. Hard to know what their impact will be on the court for the future, but I don't think we can talk about this term without keeping that context in mind.
Thank you so much, Lindquist, and welcome, friends. I'm so excited.
Let me go back now. And share from this slide. So that was Erwin Chemerinsky, and he had three trends that he saw in the term. John Roberts' court again, he wrote most of the significant decisions. It was an era of judicial supremacy. SCOTUS deferred to no one. And there is an all-time high disapproval rating. The court is out of sync with the society. I want to drill down a little bit to some of the things he pointed out, and I'll be drawing on something from SCOTUS blog again. They used to do what was this called a stat pack, which was a 30-page analysis with great graphics of what the court had done, who had agreed with whom, and so on. This year, they didn't publish it. I was devastated, and I'm afraid they're not going to in the future. So you'll see in later the graphs I'll use. I've had to use the older ones and then just add a number to it. So I'm limited by the lack of the stat pack, which is a real loss for me. But he mentioned that this year there were 58 merits cases, the same as last year. But the court seems to have stabilized at 50-something cases. But in the first decade of the Roberts Court, they averaged over 70 cases. Last year of the Rehnquist Court in 2004, they did 80 cases. And in the 1980s, they were doing as many as 160 cases a year. He doesn't offer necessarily an explanation for this decline. I'm going to assume perhaps that in such a divided political environment, coming to consensus in any court meetings is a challenge, and possibly cases are getting more complex. More than that, I really can't say. One of the surprises for people who've taken our SCOTUS classes in the past is how often the court actually is unanimous. Historically, over the past dozen years up to 2021, the average was 43%. In 2022, you'll see up here that it was 47%, slightly above average. The year before, 2021, was a low point, you'll notice, that it was only, 27%. But nearly half of the cases are historically decided unanimously, and I think most people don't understand that. You'll notice the different colors on the right of the chart. The dark purple is fully unanimous, but there are times when the justices all agree on the decision, but not the reasons for it, for example. So they might offer a judgment, offer an opinion separate, agreeing with the opinion, but offering a different way of looking at it. So sometimes that happens, but overall, nearly half of the cases are decided unanimously, which is something to think about. On this chart, I will tell you that this is the decisions by 6-3 decisions, well, no, let's look at the black line. The black line is the unanimous decisions. And as you can see, they are over time declining. And last term, as you can see, they were really low, 2021. But this year, they were 6-3 decisions dropped down to, I'm sorry, unanimous decisions went back up. 6-3 decisions, I'm confusing myself here. 6-3 decisions is this gray line, and they have been going up, although this year they dropped back down to 19%. Let's just talk about, whoops, I got ahead of myself. Let me go back. I want to talk about a different trend that was discussed by a later member of the panel. But before I do that, I want to explain something about our system. Many of you may already know this, that there are federal courts in every district courts in every state. Some states have more than one. In Washington, for example, we have 2 district courts, an Eastern and a Western. California has 5, I think Texas has 4. But every state has at least 1 district court. And so federal courts are, that's the first place a federal action is taken. And then if the loser, if you will, of the decision at that district court has the chance to appeal to the circuit court. And as you can see, we have 11 circuits, plus a couple of, actually more than 2, very specialized courts, but I won't, circuit courts, but I won't go into those. But each state is in a region of a circuit court. So we here in Washington are in the 9th Circuit. So an appeal at the district court goes to a circuit court. And then if someone wishes to appeal a decision at the circuit court, then they apply to the Supreme Court, which may or may not take the case. They can decide for themselves whether they will take the case. But that's our system. The trend is towards something called certiorari before judgment. This is something that it was new to me, certiorari or cert. Certiorari means that the court grants certiorari or the Supreme Court grants certiorari or decides to take a case. So certiorari before judgment is a petition in which the Supreme Court is asked to immediately review a decision of the United States District Court without it having been decided at the Court of Appeals. So it's skipping the Court of Appeals, the circuit court step. Such petitions, according to the SCOTUS rule itself, is only to be granted when showing that the case is such imperative public importance as to justify deviation from the normal appellate practice and to require immediate determination in the Supreme Court. The cert before judgment is on the rise, and it's not at all clear why, but this fellow noted that it's been granted 14 times since February of 2019, after having gone 14 years without granting it once. I'm going to skip over the cases, but again, I'm going to for time limit, I'm just going to have you note that that's happening more and more. And the Stephen Vladeck, the person who wrote about this, didn't have, again, offer a reason for it. It's just a trend he noticed. But the last thing that Chemerinsky pointed out was the low rating of public approval rating of the or high negative rating of the Supreme Court by the populace. And he quoted this latest number, that 30% of the population has a positive view of the court, 59% a negative view, and 11% a neutral view. And look over time at the negative, the bumps in the negative, the red. There was a bump in July of 1992 when the Casey decision came down affirming the Roe v. Wade decision. So that was caused a bump in disapproval. There was another bump in disapproval in July of 2015. That was when the Obergefell decision came down affirming same-sex marriage. And then in August of 2022, a big bump up to 42% disapproval, right after Roe v. Wade was overturned. And then this latest figure of jumping up to 59% negative, which came about after the revelations of impropriety by Supreme Court justices, particularly Alito and Thomas. And that's a segue for me to stop sharing and move to Nils, who will take over the issue of scandals. And I thank you for your attention to my data.
And thank you. And I'm just going to jump right in and share screen here. And hope this works. Play from start. Okay, can everybody hear me okay?
Yes.
Joyce, do you hear me?
Yes.
Okay, good. Nobody said anything. I was worried there a minute. Okay, I'm going to talk about the Supreme Court ethics scandal, which, you know, we haven't heard much about it lately. It was big news last summer and fall. But it's interesting, and I keep asking myself, is this really a big deal or not? But you can judge for yourself. So Clarence Thomas accepted gifts from Harlan Crow, wealthy Dallas-based real estate investor, prominent Republican donor. And just to give you an example, among the gifts he got, there was a Bible valued at $19,000 that once belonged to Frederick Douglass, a bust of Abraham Lincoln. Crow's Foundation gave $105,000 to Yale Law School for the Justice Thomas Portrait Fund. He gave $500,000 to a Tea Party group that was founded by Ginny Thomas, Clarence Thomas's wife. And virtually every year, he's accepted trips from Harlan Crow for about 2 decades and failed to report them in the disclosure reports that they're required to file. That included stays at private resorts at Bohemian Grove, flights in his private jet. There was a whole issue, I won't get into the details, about Crow buying Thomas's mother's house and then renting it back at a very favorable price. Thomas failed to disclose income his wife earned from the Heritage Foundation. There was tuition for Thomas's grandnephew that he paid for. A number of things like that. Samuel Alito also accepted trips from this guy, Paul Singer, who's a big Republican donor. Singer had cases that came up in front of the Supreme Court, and Alito had not recused himself. Recusal meaning that a justice takes no part in the case, including the argument and the decision-making. Alito's defense, just to throw that out there, is he said he was not aware that Singer was not a party in those cases that came in front of the Supreme Court. And he, in fact, went through in detail about how his staff reviews reviewed the cases, and Singer's name did not come up. And one might question whether Alito really did not know or whether it was simply convenient that Singer's name per se was not in the actual court filings. Scalia and Gorsuch themselves have faced some disclosure scandals. Other members of the court have failed to make required disclosures, then later corrected the record. That in fact happened to Sotomayor, who did disclose transportation and lodging from various law schools, but amended her records in 2021. Even Ginsburg had to amend her disclosure documents to include a $4,500 opera costume that she was given. And all have escaped any significant consequences other than, I suppose, the disclosure itself by ProPublica to the public at large that they've received these gifts and then didn't properly disclose them in the disclosure forms they were required to file. And here, just to have some visual aids, here's a bad fuzzy picture of Clarence Thomas along with Harlan Crow to Thomas's left. And here's Samuel Alito in the middle catching fish in his fishing trip. I don't know where they dug this up. Must have been posted on the internet somewhere. Okay, so the disclosure requirements for a court. Well, after Watergate, we enacted the Ethics in Government Act, 1978. This established reporting requirements for high-level government officials, and this includes Supreme Court justices. And there's a responsibility to make these documents available to the public. So the ethics law established clear-cut rules for financial behavior and consequences for violations. And in 1989, those requirements were expanded. So federal officials that are subject to disclosure requirements have to report income, dividends, most capital gains, significant debts, the purchase of sale or land and gifts, among other things. Oops, there we go. There is an exception to the required disclosure of gifts that's come up as part of these scandals, known as the personal hospitality clause. And this is how they try to squeak out of this. For example, the 20 years of Clarence Thomas taking these trips. Well, that was personal hospitality by Harlan Crow. So I didn't have to disclose that. It was an argument anyway. So the Judicial Conference is an administrative body that's established by Congress to administer the judicial branch, and it's responsible for obtaining, reviewing, and publishing financial disclosure documents of justices and judges. And why does it keep doing that? God. But the justices of the Supreme Court themselves are not subject to the Judicial Conference's interpretations of the ethics law. That is, the specific interpretations that the Judicial Conference imposes on lower federal court judges do not apply to the Supreme Court. All officers and employees of the judicial branch hold appointed positions. Title III of the Ethics Reform Act thus applies to all officers and employees of the judicial branch. However, the Judicial Conference has delegated its administrative and enforcement authority under the Act to the Chief Justice of the United States. But in 1991, the justices publicly agreed to follow the conference's interpretations, as that applies to lower court judges as well. So all that sounds fine. But they do so voluntarily rather than by legal obligation. So we have a legal gray area. If a justice disagrees with the Judicial Conference's interpretation of the statute, or more likely simply thinks that the conference's rule doesn't apply to the specific financial interest at issue, even if others would disagree, there would be no way for anyone except for the Chief Justice to overrule that decision. Getting back to the personal hospitality clause, it does not require an official, including a federal judge, to disclose gifts of food, lodging, and entertainment that are received as personal hospitality of an individual. And the Supreme Court justices, as I've noted, have relied on this to justify not disclosing gifts that it would appear that they otherwise have to disclose. Alito and Thomas each alluded to this clause in their response to the ProPublica reports. However, it doesn't apply to transportation. The individual extending the hospitality also has to be the one paying for it, not an entity such as a corporation or any other individual. Any gift or favor that's extended at a property owned by a company, even if the individual that's extending the gift wholly or partly owns the company, must be disclosed. So two aspects demonstrate the problems with Thomas's disclosures. The regulations explicitly state that a personal hospitality gift must come from an individual's own pocket, not from a company or entity. And Crow's Jet is likely owned by an LLC. I'm not quite sure why we don't know that. Transportation, for example, private jet travel or yachting adventures have to be disclosed. And this means that these guys are going to need to go back and amend their statements, which I think actually they have done at this point. I should also note that Thomas has failed to recuse himself in January 6 cases, despite investigation of his wife, Ginny Thomas, by the January 6 Commission, which has also been an issue that has been brought up in all of this mess. And go forward. There have been some attempts to deal with this. In particular, there was a Courthouse Ethics and Transparency Act that mandated the creation of an online database for the financial disclosure statements. And Representative Johnson and Senator Whitehouse have reintroduced the Supreme Court Ethics, Recusal, and Transparency Act. And Jayapal and Warren reintroduced the Judicial Ethics and Anti-Corruption Act. Both of these bills have various ideas for strengthening the financial disclosure procedures that apply to the Supreme Court, but neither has yet become law, and it seems somewhat unlikely, given the current state of our House and Senate, that either will become law anytime in the near future. In Alito's case, in the years after his fishing trip, we should note, Singer's hedge fund came up before the court at least 10 times in cases where his role was often covered by the legal press and mainstream media. This is essentially an argument that Alito should have known, even if he was not technically named in the court filings. Alito went ahead and participated in that decision, voting in Singer's favor, essentially, and the hedge fund ultimately received $2.4 billion. And there we go. And you may or may not have heard about in November, the Supreme Court itself, as a response to this, is my interpretation, created its own court code of conduct. It has 5 canons, so-called, in that code of conduct. It's about 9 pages long in actual text, which is not especially long or detailed. And you can see them there. Justice should uphold the integrity and independence of the judiciary, avoid the appearance of impropriety, perform the duties of office fairly, impartially, and diligently. And then Canon 4 talks about extrajudicial activities that are consistent and those that might be inconsistent. And 5, how they should refrain from political activity. Canon 3, which talks about performing the office fairly, impartially, and diligently, covers the situations where a justice should ideally recuse themselves. In particular, a proceeding in which the justice's impartiality might reasonably be questioned. That is, where an unbiased and reasonable person who is aware of all relevant circumstances would doubt that the justice could fairly discharge his or her duties. This includes personal bias or prejudice and financial interests. Financial interest can be cured by divestment of the interest. The criticism against Clarence Thomas is I don't think he can cure the bias created by his wife being investigated by the January 6th Commission. Canon 4, extrajudicial activities, covers gifts. And essentially, this says a justice should comply with the restrictions that are already set forth. So essentially, the rules about gifts are not changed by this code of conduct. Canon 5 says that justices should not engage in political activity, and it's a blanket ban while they're in office. It does not cover family members specifically, unlike other provisions. So the code of conduct was signed by all the justices, and it does not really include anything new of significance. And a cynic might say that it was simply created in order to make it look like the court was doing something about the issue. The gift disclosure rules and requirements remain the same, and there is no enforcement mechanism that's beyond the limited options that are open to the Chief Justice and Congress. And I put this link at the bottom here. This is a very good discussion of the code of conduct that came out and the courts dealing with the ethics rules and how one might realistically say deal with the issues that have come up. It's basically a discussion between two different people, one an attorney who is two reasonable, rational attorneys, one on the left, one on the right, talking about the different issues involved. And if you're interested in getting into more detail about this code of conduct that they have promulgated from Virginia UVA's law school. All right, and going forward. So what power does the Chief Justice have over fellow justices? Well, the most prominent role is that he's the presiding officer of the court. In that capacity, he presides at the private conference in which the court decides which lower court decisions to accept. He presides over the public sessions as well. He chairs the private conference at which cases are discussed among the 9 members of the court, eventually decided. And he assigns cases when in the majority. The writing of the court's opinion, whether it's to himself or to one of the associate justices. But really, that is it in terms of the power of the Chief Justice. He really doesn't have any power to come down on his fellow justices about ethical lapses beyond, I suppose, he could censure them in public, or he could, let them write fewer opinions if that opportunity comes up. But that's probably the extent of his power. Now, of course, we also have the power to impeach judges. Supreme Court justices shall, under our Constitution, shall hold their offices during good behavior, which has been interpreted to mean that it's a lifetime appointment. But they can be impeached, which under our current Congress, as I've noted, is probably unlikely, unless it's a really significant breach that's committed by a particular justice. It's interesting to note 15 federal judges have been impeached in our history. Of those 15, 8 were convicted by the Senate, 4 were acquitted by the Senate, 3 resigned before an outcome at trial. The last of these was about 14 years ago, Thomas Porteous of the U.S. District Court for the Eastern District of Louisiana. He was accused of accepting bribes and making false statements under penalty of perjury. He was in fact convicted and removed from office. The only Supreme Court justice ever to be impeached was Samuel Chase in 1804. He was charged with arbitrary and oppressive conduct of trials, but was in fact acquitted by the US Senate. So the bottom line here is there's really very little that can be done to regulate the Supreme Court with respect to their ethics if they don't want to regulate themselves. Now, it is generally believed that Congress has the power to pass a law that would govern the ethics of the court and possibly govern the behavior of the court in other ways. But both the Chief Justice and other justices have questioned whether Congress in fact has very much power to do this, given their status as an independent branch of the federal government. And that ends my presentation. And oh, there's the button. Thank you. I'm sorry.
Okay, thank you, Nils. Next, we'll turn it over to, I will be sharing Tony Carfagnini's slides. So let me try to do that at this point. And I'm going to start here, but I'm going to quickly get past that with the misspellings and turn it over to Tony.
Thank you, Terry. Mine is much more general overview. We expected that the audience would be mostly American and perhaps less familiar with our court. So mine is much more an overview. So if we go to the next slide, it was suggested by others that I just put up a map to get. I'm going to give like geographic and historical perspective on Canada, the U.S. So Canada is a big country. It's the second largest in landmass. Most of the population is about 100 to 200 kilometers north of the American border, though. So it has provinces, but it also has territories. Yukon is a territory. Northwest Territories is a territory, and there's a new government that's somewhere in between, which is Nunavut, which is largely now Indigenous governed, and that's still undergoing a devolution of powers process. So if we go to the next, we'll do some brief history. North America was, colonized, all of it, the northern part and most of the rest of it by the French initially, who developed the fur trade and went really far through the west and south and whatever for 150 years before these events. But as a result of the 7 Years' War, Great Britain defeated the French in a battle at Quebec, and the English came out of the 7 Years' War as the dominant world power. The French and English, of course, have been fighting for hundreds and hundreds of years, and this was one stage in that process. 1763 is a really significant date, particularly for Indigenous people in Canada. That the territory changed. So it had been run as a colony of France. It now became a colony of Great Britain. But what they got was a huge territory that was populated by Indigenous people and French-speaking people who were Catholics. So in the 18th century, neither of those people were in great favor with the powers that be in England. There has been a history of religious wars that went on. So they very pragmatically, however, realized that if they wanted to keep the colony that they had gotten in North America, they would have to recognize and allow the people that had been there to continue to exercise their rights. So for the Indigenous people, there was a specific proclamation by George III, and it established that the Aboriginal territory, which was west of a treaty line that ran along the Appalachians was to be Indian territory, and they were not to be dispossessed of any land in that area by anybody. And that is still the constitutional basis for Aboriginal rights in Canada. So about 10 years after that, things were starting to get restless in Boston and other places. The British were dealing with a population in Quebec that was Catholic and French speaking. So they specifically passed legislation called the Quebec Act, which protected the French language and the Catholic religion in the province of Quebec. Canada still has special rights in its constitution, both for French speaking, as well as for Catholic religion, as well as Indigenous rights. And they arise out of the history. So at the end of the Revolutionary War, a lot of loyalists moved north, and that determined to a great extent what the character of Upper and Lower Canada, as they were then called, would be. And shortly after that, the U.S., which had acquired, sort of as a result of the wars, most of the Ohio territory and the area to the west of that previous treaty line, they actually purchased from Napoleon 530 million acres by the Louisiana Purchase. They didn't bother to ask any of the people living there about it, but they purchased it for that amount of money. And the Western colonization continued. And that's a whole other story. Now, that warfare between Indigenous people and the settlers continued throughout that period. And at the end of the War of 1812, the boundaries remained unchanged. So in 1815 was when the war ended, but it was virtually the same. The big losers in all of this were the Indigenous people who didn't have a seat at the conferences where these things were decided, despite the fact that they were very much a military force at the time. So that's the sort of backdrop of why some things are the way they are in Canada. And they're still being debated and decided upon today. So our Canada also didn't become a fully independent country all at once, like America did. It develops in stages. So there's various things that together comprise our Constitution. The first thing was we had 5 or 6 colonies in British North America in the 1860s. And they got together and decided that they wanted to have a government of some kind of themselves. So the British North America Act is actually a piece of legislation, a piece of English legislation, which established the Dominion of Canada with those 5 or 6 provinces. And it wasn't until several years after that that the Supreme Court of Canada was established. Just a note to illustrate this sort of gradual process of becoming more independent of the British Crown. Appeals to the Privy Council, which is the House of Lords in England, still remained from a final decision of the Supreme Court of Canada up until 1949. 1949 was when the last province joined Canada. Newfoundland was a colony of England throughout the Second World War. And it wasn't until 1949 that Newfoundland and Labrador became part of Canada. Okay, so now let's look at the court. Next slide, please. So the Supreme Court of Canada hears appeals from the courts of appeal of all of the provinces. It also hears appeals from the Federal Court of Appeal. We do have 2 systems of courts here. We do have a federal court, which hears exclusively matters arising out of federal legislation. But most cases are dealt with in provincial courts. So we have a provincial court, then we have a superior court, a superior trial court in each province. And then we have a court of appeal for each province. So appeals from the Court of Appeal go to the Supreme Court of Canada. You have to apply for leave to appeal, much as I think is the case with your Supreme Court. It has to be a case that the Supreme Court feels is a new point of law or something that really decides it needs to be settled for the whole of the country. Some cases you have conflicting legal principles being advanced by different courts of appeal. So that's the kind of thing where the Supreme Court will hear a case. There's another area where the government of Canada can refer constitutional questions to the Supreme Court for a decision. So they can state a case and send it to the Supreme Court for a decision on what the law is. Next slide. So we have 9 in total, a Chief Justice and 8 other judges. 3 of the justices must be from the province of Quebec. That's right in the legislation. They are appointed by the Prime Minister. So the Prime Minister is the head of the government. He is the leader of the party that has the most seats in Parliament. And if there's a non-confidence motion in Parliament, there's an election and the Prime Minister has to run again. It's not quite the same as yours. We have a mandatory retirement age for judges. They have to leave at age 75. And more recently, there's been an effort to make things a little more transparent in terms of the appointment process. Ultimate decision is made by the Prime Minister, but there's now an 8-person advisory board, and it was established several years ago. And 3 of this advisory board are nominated by the Minister of Justice, 1 by the Federation of Law Societies of Canada, 1 by the Canadian Bar Association, 1 by the Indigenous Bar Association, 1 by the Council of Canadian Law Deans, and 1 retired judge. So the advisory board receives applications and then they shortlist. So they'll submit 3 to 5 names to the Prime Minister to say, these are the people we feel are the best qualified to fill the vacancy that you need to fill. And there's a lot of more detail about all of that. And there's a website at the Office of the Commissioner for Federal Judicial Affairs. I didn't give you the link, but you could look that up by Googling it if you wish. Okay, next. Just comment on recent appointments. There is an effort to have gender balance and diversity. So in recent appointments, in 2021, we had Mahmoud Jamal, Ontario. He came from the Ontario Court of Appeal, and he's the first visible minority member of the court. He's actually Baha'i. One would think from the name that he might be either but he's not. He's Baha'i, actually. In 2022, the first Indigenous member of the court was appointed, and she's from Ontario. Last year, Mary Morrow, who is on the Court of Appeal in Alberta, was appointed, and now a majority of our Supreme Court are women. Now, although there isn't a written rule, there's like sort of a convention, a constitutional convention with respect to regions. As I say, it's a very, very big country. The East Coast is very different from Central Canada, and Central Canada is very different from Western Canada. Those tensions, if you read any Canadian news, you'll know that those tensions still exist quite a bit. There's a lot of regional tensions in the country. So the government, in the person of the Prime Minister, will try to keep it at having 3. Well, the 3 from Quebec are legislated. He has no choice about that. But there's usually at least 1 from Atlantic Canada and at least 2 from Western Canada. So Mary Morrow was appointed to replace a judge who retired early, who was from Alberta. So she replaced him as one of the Western representatives. Okay, next stage. This isn't specifically with respect to the court, but I think it's something that's different in our 2 countries, and I wanted to deal with it a bit. the public prosecutors are not elected in Canada. We call them crown attorneys. They're employed by the province or by the federal justice department as civil servants. They are represented by unions. They don't change with changes of government after elections. Also a federal office of public prosecutions that is designed to be independent of political influence. We had a big scandal a couple of years ago, 2-3 years ago, when the federal justice minister of Canada, who happened to be actually an Indigenous woman, resigned in protest after the prime minister's office attempted to influence the prosecution of the engineering firm SNC-Lavalin for international bribery offenses. Pressure was being exerted by the prime minister's office to suggest that they make a deal, that they do a plea bargain kind of thing. And even that suggestion was quite outrageous from the Canadian point of view, and she resigned. Okay, next page. So there's always this issue of whether judges make law or not. I mean, we could talk a lot about that. There is a doctrine that applies a parliamentary supremacy, meaning the legislature, or in your case, Congress, it makes the laws, or the state legislatures, they make the laws. They're the elected representatives who make the laws. And the judges are only supposed to interpret those laws as they apply in specific situations. Now, they're supposed to, the law is that they're required to follow principles established by previous court decisions. But they can come to a different result if the facts are different. So a new fact situation can result, or does result, in the development and change to legal principles. There's a big discussion that could take place about that, because I don't think the Supreme Court, from what I've heard over the last few years, has quite the same level of deference to previous decisions of their own court as we do in Canada. The legal principle is, if the Supreme Court of Canada said this was the law in this situation in 1945, that's the law. If that situation comes before you again, it shouldn't even come to you again, because that's the law. There's not even an appeal based on that. Whereas you do find the Supreme Court overruling its own precedents, it seems. Now, I don't know, because I have not read those cases. What judges tend to do is they tend to avoid the issue, they tend to distinguish them. They say, okay, that was the law we decided based on that particular set of facts. These set of facts are a little different, therefore it's not the same, and we can come to a different decision and establish a different principle. The public doesn't see those distinctions, though. The other thing that the Supreme Court can do is can strike down legislation. Now, when we're talking about the relationship between the executive and legislative branch and the judicial branch, if the government passes a law that citizens feel is contrary to the Constitution, and namely our Canadian Charter of Rights, because it offends certain fundamental rights that are granted by that, that case will go through the provincial courts, but will eventually find its way to the Supreme Court of Canada, and they can strike down legislation. We just recently had that happen in Ontario. We don't know where that decision is going to go. Well, actually, we had it happen in Ontario and in the federal sphere within the last couple of months. In Ontario, the Court of Appeal in Ontario has said that the Ontario legislation imposing a wage cap on public servants by legislation that was passed 2 or 3 years ago is unconstitutional. That's going to be appealed to the Supreme Court of Canada and may or may not stand. We don't know. The Supreme Court has also recently decided, oh no, it's not the Supreme Court. The federal court has decided at trial division that the government of Canada acted illegally in invoking the Emergency Measures Act to disperse the truckers' convoy occupation in the capital a couple of years ago. Again, that's under appeal, and we don't know what the result will be. But laws that are passed by the legislative branch are subject to review by the court. And I think that's the same in the US. Next. Next slide. Harry? Yeah. I wanted to talk a bit about Indigenous rights because I do a lot of that. I don't do rights cases. I'm not a litigator. I don't go to court. I'm more a business lawyer, but most of my clientele are Indigenous organizations or First Nations, as we call the communities here. And in terms of how does the public how are social issues dealt with, and how does decisions of the Supreme Court change our society? And I think there have been a lot of changes in the last 20 years in this area of Indigenous rights. I'm just giving 3 examples. There was a case, Daniels, and it decided that Métis people, who strictly speaking are French Indigenous mixed race, have equal Indian status under our Indian Act, which initially was drafted to apply only to Indian and Inuit people. A lot of controversy around that, a lot of controversy about what is a Métis person, and it's causing a lot of disruption, a lot of activity. And I'll explain why after I finish the 3rd point. The 2nd point is that over the last 20 years, the courts have increasingly recognized the right that Indigenous people have to be consulted about and accommodated or compensated for resource development on their traditional territories. So those are areas often beyond the boundaries of the reserves. The reserves that were set up initially were very small, but in many of the treaties, rights to hunt and fish and rights to continue to use the larger territory to sustain the way of life were guaranteed. They were immediately broken and eroded over the subsequent 100 years, but now things are coming back. And so we have a bunch of cases now being decided where recent human rights cases concerning the survivors of Canada's residential school system, the underfunding of Indigenous child welfare, and the failure to provide drinking water on reserve are providing for significant payments. So there's a lot of money that is flowing, and it's well publicized, flowing to Indigenous people. That has been causing a bit of resentment, I would say. And it's also causing the issue with Métis. Everybody wants to be an Indian now because there's money. I hate to be blunt about it, but you know, I've been practicing law for an awful long time, and I tend to I tend to follow the money when I think about things that way. And in my personal practice, I work for a First Nation, which is an Indigenous group, and I know how they feel about certain of the Métis. Certain of them are certainly a group that was not dealt with properly by the new government of Canada in 1870 when the province of Manitoba was created. It was a great betrayal by the government, which at that time was dominated by white Anglo-Saxon Protestants. And in addition, the Catholic Church also stabbed the Métis in the back on that, and basically they lost everything. So there's a legitimate grievance there, and there's an identifiable group. But there's also a lot of controversy elsewhere in the country. Anyway, going off topic. Next slide. So Indigenous rights are protected in our Constitution. Our Constitution actually, the last part of it came into completion only in 1982, believe it or not. That's when we became completely free of final appeals to the Crown in Great Britain. Although Indigenous people still will go to Great Britain and to King Charles to say, we made our treaty with you in 1763. We didn't make it with the government of Canada, which did not exist in 1763. We made our treaty with you. And so they will still continue to go back to the relationship with the Imperial Crown. So in Canada, most First Nations signed treaties, but many did not. In fact, in British Columbia, there were no treaties until recently. So the treaty making process is still continuing in Canada. We have modern treaties that are still being negotiated and addressed. Indigenous rights are being asserted and enforced by the courts now more than they were in the past. In my area, there's a big case called the Annuities case. And in the treaty that dealt with this part of Canada, which is north of Lake Superior, the treaty indicated that it would give to each Indigenous person an annuity. It was, I think, $2 a year back in 1850. They gave them a big raise up to $4 a year, sometimes throughout then. But the problem for the government now is that there's a clause in this particular treaty that said, but if we ever are in a position to be able to afford to give you more as a result of the resources that we draw out of this land, we will increase it. Well, they got sued. I know the lawyer who's in charge of the litigation. They won. They won at the trial level and they won at the Court of Appeal. The third phase of this litigation is to assess the amount. And as you can imagine, it's a big, big number. That is being now followed by other treaty cases across the country, which have the annuity provision, but they don't have the provision about increasing it. So all this is to say that the courts are being invoked by Indigenous people to assert their rights. They're succeeding in many cases, and lots of money is flowing to Indigenous communities. And some people don't like it. There's another recent case that came up, this goes beyond the scope of today's presentation, but there was a recent case that involved the Kanesatake Reserve. So this is a community that was a Mohawk community back in 1763. It was there before the United States of America. It was there before Canada. It's still there. Mohawk people still live there. They feel they have the right to trade tobacco across the border. Canada has decided, no, you can't do that without paying tax. That's been a constant battle for decades. So it's gone to court, and the trial level is basically saying, nope, the Indians are right. They had a covenant chain agreement going back to 1700s, and there's a treaty on this, and you cannot do that. So it's under appeal. But as you can see, these things are constant in our courts, very much followed by the public. And I find it very interesting because I've seen a huge progression in the 40 years that I've been practicing in the area. I was called to the bar in 1979. So that was before the Constitution Act of 1982. So when I went to law school, there was no Indigenous law taught, because it was just starting, but it's a huge thing now. So there was one other thing that Terry brought up in something he saw lately, which is how the public, it's a survey done by, I'm not sure who. Terry, did you want to speak to it?
Well, I wish I knew the company, but it was published in the Globe and Mail last Saturday, so therefore I thought it was relevant. And well,
yeah, it shows that the Supreme Court has the highest public opinion rating other than universities and colleges, the healthcare system, and charities. Supreme Court is next, and you can see that the House of Commons is way below that. Yep. So the public seems to be fairly comfortable with the way the Supreme Court of Canada operates. We haven't had the scandal issues that you have had. Now, maybe they just haven't gotten caught. I don't know. As far as disciplining judges, we do have a Canadian Judicial Council that if there is really bad behavior by a judge, they can be terminated and dismissed. It's judges. It's a group of judges that decides on the fate of other judges who go beyond the level of conduct which is required. But as to what would happen in the case of a Supreme Court of Canada judge, that it just really hasn't come up because we haven't seen or heard of that being an issue. It does not seem to me to be as partisan, or it seemed to be as partisan a process as it is in the US. We don't look to the judges to say he or she was appointed by this government, therefore they're going to decide in that way. There doesn't seem to be that perception. I don't know, haven't studied the court enough to know whether there's any perceptible bias based on what your political background was before rising to the court, but it doesn't seem to have the same intensity there. And that's all I wanted to say about that.
Okay, well, thank you, Tony, Nils, and Joyce. I've enjoyed your presentation, and I've learned a lot about both my own Supreme Court and that in my neighboring country. So thank you very much for sharing your time and your expertise. In a time when our nations are hamstrung with so much division and polarization, it is both comforting and scary to hear the power of our Supreme Courts to stand above or enter into these frays. We'll give our speakers a short break and to collect their thoughts about the next round of questions and comments from you. While I again share the screen here to put a little plug in there. If you've enjoyed the presentation and you'd like to join NAUA, we'd love to have new members. If you join, it doesn't cost anything. You're encouraged to make a donation when you can and are able, but you will receive twice a month an email with the activities that you can participate in, including a monthly service, and there's now a new book club, and there's new conversation circles, and we're continuing to add programs. So I would encourage you to go to the site naunitarians.org. And if you wouldn't feel good without donating a few bucks, you can click on that QR code and do that. And it also reminds you that the recordings of all of I think we've had maybe 10 Academy sessions thus far, and the monthly services, they're all available on the website at naunitarians.org. Okay, let me just stop sharing that. And finally, let me tell you about the March Academy program scheduled for the second Tuesday of the month, which will be our regular evening. It's Tuesday, March the 12th, 4:30 p.m. Pacific time and 7:30 Eastern time. And you can join using the same link you used today. And if you forgot that, you can certainly go to the website and look at the calendar and pick it up there. We also encourage you to register for Academy sessions. It's nice for us to be able to keep a track of who's participating, but it's nice for you in the sense that if you register, you'll get a confirmation that you are registered, but you'll also get an email 2 days before the presentation just to remind you. The March program is entitled I Before We, Except Overseas. It's a bit obscure. It traces the roots of our multi-century identity crisis. Most cultures of European descent cultivate individual identity more than other cultures of the world. We have to go back 60, 100, or perhaps 300 years to find the roots of our contemporary debates over the role of identity in our society. One intriguing theory is that this focus on individual identity has been intentional and has a distinct purpose. This talk will look at some theories that help explain how we have ended up increasingly destabilizing disagreements about culture and politics in North America and Europe. Many of you will recall hearing Ken Ing, who will be our speaker, and I think he's with us this evening. For us, it was a record attendance at an Academy session when he talked about left versus left, what it is ain't exactly clear. And he addressed directly the kind of political challenges that from the new left as well as from the old right wing.